buying names and things of that nature. I'd greatly appreciate it, especially when we try to either live stream or get the information on our website the same day. So if council, please keep that in mind during the argument, it would be greatly appreciated. You've already received the packet of information about how we conduct these virtual hearings. I just want to remind you that what will happen is when a justice has a question, they'll raise their hand or their virtual hand. Once you see that hand come up, if you would please pause in your argument so that I may call on that justice to ask the question. That would be very helpful to me. When you are not speaking, please turn off your microphones. Normally we have control over that. Today we don't. So please try to remember to shut off your microphone when you are not speaking. Is counsel for the appellant ready to proceed?
Yes, Your Honor.
Thank you, counsel. If you identify yourself for the record and let me know how much time you wish to reserve, if any, for rebuttal.
Yes, Your Honor. Attorney William Bilczek for the appellant plaintiff, reserving 5 minutes.
Okay, counsel, I'm having some problem with your audio. Could you speak again, please?
Yes, Your Honor. This is Attorney William Bilczek. I'm representing the appellant plaintiff, John Doe 3, and I'm reserving 5 minutes for rebuttal.
Okay, your audio isn't very clear, but I think we can deal with this. Madam Court Monitor, is it clear enough?
I'm hearing him okay so far.
Okay, thank you very much. Counsel, whenever you're ready. Oh, I'm sorry, one more thing. Justice McDonald will be our timekeeper. He'll hold up signs when you have 5 minutes, 3 minutes, and time up. Thank you.
Yes, Your Honor, and fellow justices. Just to let you know, I did watch the preceding John Doe 1 arguments as was requested. So I'll move forward. The plaintiff's case is grounded in negligence. The statutory duties were pled, or the regulatory or policy duties of the town of Madison were pled in the plaintiff's third amended complaint. Motion for summary judgment was granted based upon the lack of evidentiary proof.
Excuse me?
Yes.
I was just informed from IT that they would like Attorney Bilczek to get closer to his microphone. Thank you.
My apologies, counsel. Please continue.
Okay. The trial court found that the plaintiff presented insufficient evidence to give rise to genuine issue of material fact regarding the question of whether the defendant violated the ministerial duty imposed by the Mandated Reporting Act. The court went on to state also that the plaintiff's claims should be barred by government immunity pursuant to state statute 52-557N. Before I get into the facts, I would like to, since I watched the first argument, I just want to explain to the court that while a lot of the facts are identical to in all three cases, in my client's case, that being John Doe 3, the plaintiff was a 15-year-old boy and did not immediately report to the school or to the police authorities his full involvement due to fear of mafia reprisals as threatened by Allison Marchese, being ostracized by his fellow students and the public, as well as on social media. This had been all taken place as soon as the news broke about Marchese's arrest. The record showed that Doe 1 and 2 advised the authorities that the plaintiff was involved, and he was interviewed by the Madison police shortly thereafter. It seems that when he was asked by the police if he was sexually assaulted by Marchese, he took that to mean vaginal or oral sexual assault, as which happened to Doe 2. He did not tell them about her physically assaulting him on numerous occasions when Marchese hugged and sexually hugged and kissed him behind closed and locked door in her classroom during school. From there on, the police and school board did not make any further inquiries into my client's participation, what took place between Marchese and the other two John Does. However, the police knew, and I believe the school authorities knew, that he was involved to a certain degree. And the defendants really didn't realize that he was sexually assaulted at the time that she was arrested. Following Marchese's arrest, the school set aside a date.
Thank you, Counsel. Justice Keller?
Thank you, Chief. How did the school officials know he was involved to a certain degree? You're muted, Counsel.
According to the plaintiff, he had, following the report of Marchese's to the school authorities, he had discussed with one of the DOEs that they had explained that he was involved. And this is why he was called into the police. So I imagine that is how.
No, my question is, before this all came to light, how did school officials know that your client was, that there was a reasonable suspicion that your client was being abused? How did the school authorities know before any of it came to light?
Is your question as it came to light?
Well, you made a statement that the school officials knew that he was involved. And are you only talking about after this all came to light or before it came to light?
After it came to light.
Okay, thank you. All right.
Okay. Well, following her arrest, the school decided to hold a day of counseling. The other two John Does were told that they could stay home. They did not show up. He was never advised. So he went there and was inundated by questions by all the students. All the students knew what was going on, and the defendants in their defense saying that they knew nothing, which is hard to believe. He was inundated with questions, and he suffered tremendously and became very depressed. And at one point, one of his teachers and football coaches came to him and asked him and talked to him, say, "Hey, look, I heard what was going on. I know you're involved, and if you need me to talk to someone, I'll be there." Yes, Your Honor.
Justice Keller?
All the students knew he was involved. Was there evidence of that before the trial court in the form of depositions from students?
None of the students were called because they were all minors at the time.
So you didn't take the depositions of any students. So how do you support that statement that all the students knew what was going on?
I can only tell you what my client, when he was deposed, he explained that.
Is that part of his deposition? Does he make that statement in his deposition that all of the students at the school knew what was going on?
Say all the students, 100%, Your Honor, but he was inundated with questions to the point that he got.
Well, this is afterwards, though.
Correct, Your Honor.
Again, you made a statement, all the students knew what was going on, which seems to me to indicate that it was obvious what was going on and what the heck was wrong with the teachers, because when all of this was going down before she gets arrested, all the students knew what was going on. Where's the proof of that in your summary judgment submissions?
Your Honor, I did not say beforehand all the students knew.
Okay, all right.
After the arrest of Marchese.
Okay.
Okay, so he had this.
Counsel, there's a question from Justice Doria.
Yes, Your Honor.
What was your client when he was asked the questions where he didn't understand that they meant something other than physical assault, sexual assault? What was he being asked questions for then? Were they just asking all the students, or who asked him?
Well, one of the police officers investigating the matter. Your Honor, he was their first time ever before a police police officer. He was shaken to the boot.
Yeah. I'm not criticizing him. I'm just trying to get the chronology right. So he was asked the question, and then he answered it as he answered it. But there came a time where you're saying it was only after she was arrested, Ms. Marchese, that he came forward to say that this was, and I'm not judging that. I'm trying to get the chronology right. Was there a time where you keep using this term, he was involved? Was there a time between when he talked to the police and when he finally, came forward to say I was assaulted, that he was somehow, was he friends with the other two does, that the other students knew he was, what was their suspicion that he was involved in some fashion?
Yes, right. So he was like best buds, best friends, almost like John Doe 1.
I gather that.
John Doe 1 and 2 decided to report Marchese, and they had a conversation before they reported Marchese, saying, I don't want to get involved in this.
I see.
And they reported to the principal solitary, and at that point in time, there was an investigation started by the police. The police then called my client in after they talked to John Doe 1 and 2. They discussed with him about this quote being sexually assaulted, and then they closed the investigation, and that's at that point in time Marchese was arrested. So chronologically, I'm just explaining what happened.
So then, can I assume, or you can correct me if I'm wrong, that your position on whether there was a ministerial duty, mandatory reporting, is based on the same record, the same things that you would claim are chargeable to the defendants for being known as the other two defendants? If that's not true, tell me. But can I assume that?
Yes, you can, Your Honor.
Okay, thank you.
But one, Justice Keller.
Oh,
I see hands up.
Hang on, Justice Keller.
you're muted.
Justice Keller, you're still muted, I believe.
I'm sorry, I meant to lower my hand. I don't have a question.
Okay, Justice Doria.
I am all set, but you finish your answer as you see fit. Sorry about all that.
So, when this day of counsel took place, he was approached by one of the teachers he was friendly with, who was also a football coach, and said, "Hey, look, I heard, I understand you're involved." He discussed the matter with the coach, and he said you could talk to me anytime. In fact, next, he approached a teacher that he was friendly with, who had Teacher Pagliuto, and he basically explained to Teacher Pagliuto that he told him the whole story. Now, finally, he spoke to his show choir teacher, Teacher Soja, and explained what took place. None of these teachers, after hearing my client in depressed condition and in sorrow, and explaining what took place, never reported it as required by the Mandatory Reporting Act. Yes, Marchese's. Yes, right.
Counsel, your timeline's confusing me. Was this after she was arrested?
Correct, Your Honor.
And so after she's arrested and becomes public, you're saying there's still a duty to report what happened before she was arrested?
Correct, Your Honor. Because the facts, if you read the facts, my client eventually was put into a class with Mr. Marchese, the English teacher. And he knew that he must have been involved in the matter because of, so I'm just saying, going down the road, the constant, no one knew, that's what they're claiming. And then when he was put to into Mr. Marchese's English class, he asked to be removed. And he explained to the guidance counselor who was trying to take him out of the class the reason why. But they said they couldn't do anything, so he sat through the class for a whole semester.
So I'm just trying to figure this out as a tort. The duty was mandatory reporting. The breach was that the people didn't report after the arrest for things that happened before the arrest because they found out after the arrest.
Correct, Your Honor. I know it's confusing in that sense, but the fact is he was physically abused. The teachers found out that he was physically abused. At that point in time, the teachers probably did not know that he had been physically until they spoke to him. At that point in time, they should have come forward because Marchese was only charged with sexual assault or for DOE 1 and 2, and the charges were never brought up against her for what she did to my client.
Okay, thank you.
Now, under the mandated Reporting Act, once the teachers found this out, once again, if they see it or hear it, they have to report it. That is basically, that's what Salvatore said in his deposition. No question, it's a judgment-free zone. They don't want teachers trying to do their own investigation. They just say, look, if you hear about something, you report it. So they didn't do their job under the statute. Also under the statute, also under Madison's DOE policy regarding child abuse. Now, also, in my brief, I bring to attention, which the court did not put any credence on, was that going back during the summertime when they had football practice on the school campus, but not during school hours. And this is the part which, I disagree with the court's position saying that that it has to take place on the school campus during school hours. The coaches, who were all employees of the Board of Education, saw Marchese performing her core training exercises in the middle of the field, surrounded by the entire football team. Yes, Justice Doria. Any questions?
I believe Justice Doria's hand is still up from last time. Sorry about that, counsel.
So, all the football, she came to practice after a run that she would do 3 times a week. Come to practice 3 times a week to do the core training exercises. And her outfit would be really short shorts, so thin and so short that my client testified that he could see right through them, could see her thong, could see her private parts. And this became the big talk among all the football players. And this went on for this training workout session went on for 4 to 5 weeks. So they were exposed to her for 12 to 15 times. All the football coaches saw what was going on. They made locker room jokes and discussions about what they were seeing. Some of the coaches said it was inappropriate. Yes, Your Honor.
Justice McDonald.
Thank you. So, counsel, if the exact same clothing was being worn and at a beach, and one of the students came upon her at the beach and saw her in that attire, would that also be a reportable offense in your view?
I don't believe so, Your Honor, because once again, it's out in public. This is more in a scholastic environment. Football practice during the summertime, it's only for registered students. So this is, I can't tell people how to dress. Once again, defendants stated that there is, under the labor agreement with the town, there's no dress code. But let's put it this way. Any teacher walking into the high school can't just walk in wearing their bathing suit or birthday suit. It's just, there is some professionalism.
So, okay, and what about in a gym? If she was in a gym and the students were at the same gym and she was in the same attire, reportable event?
I can't say it was reportable, Your Honor, but gyms have rules and regulations themselves of what you can and can't wear. It's posted.
Okay, and my final question is, it was a hot summer apparently, if one of the male coaches removed a T-shirt and was bare-chested, a reportable event?
Quite possibly, Your Honor. It works both ways. We can't decide whether it's female or male or female. We have to, the law is the law. And the regulations say that there could be men attracted to men. If they see the bare chest, this could be flirtation on their part. I can't make that call, but I believe it's justified. But then again, there's testimony that any of the coaches take their clothes off, and some of the coaches said, God, no, because of their condition.
Thank you.
Justice Keller.
Thank you, Chief Justice. Attorney Bilczek, you talk about your client was mentally sexually abused. Why don't you need expert testimony to prove an allegation like that?
I don't believe you need it because, once again, under your case at Osborne, it basically said that in school environments, you already have the child abuse guidelines, which apply to teachers who are laypersons. And they, as teachers as laypersons, they just basically have to make the common sense or the reasonable suspicion judgment.
Well, are you kind of claiming that, like, could she be arrested for risk of injury for wearing skimpy gym clothes?
In front of students, yes, Your Honor.
You think she could be arrested for risk of injury? Okay.
Once again, the clothing that she was wearing, it was not typical of what coaches wear. Yes, you might see it on the beach, but that's her personal time. She's not coaching, teaching students who are impressionable. These are 14, 15-year-olds, which some of the DOEs and my client were at the time.
Counsel, do you have any case law that supports that argument that you can wear clothing at the beach, but you can't wear it in the school? I mean, I'm having problems with that. Let's say you had a cycling team and they wore the tight-fitting spandex cycling gear. And the coach decided to wear it too to show that, you know, the team spirit. Under your theory of the case, that person would be subject to mandatory reporting.
I don't believe so, Your Honor, because if
Why?
you know, because they would have to be so explicit of the clothing that they were wearing that it would raise suspicion on, like I said, reasonable suspicion that this was wrong and that it should be reported. I don't believe your analogy is on point regarding.
So, but I'm trying to figure out this. This goes to you said you heard the other argument. This goes to the issue that I was saying that at some point I could see that it becomes mandatory, but there's a spectrum, and I'm trying to figure out if it's near that mandatory point or not so near that mandatory point. Some of these things are discretionary.
I understand, Your Honor, but in this particular case, her clothing was so explicit that it revealed her genitals. You could, my client said, basically you could see her buttocks, her thong. They could tell the color of her thong. It was exposure. And at one point in the testimonies, one of the witnesses said that when she was doing her mountain climbing exercises, when she was bent over backwards and pumping her legs, that the guys were ogling her or looking at her. And she said, basically, keep your attention on the exercise. So she was aware of what was going on and continued to do this. She knew.
Please continue. Thank you. You have 3 minutes, counsel.
Okay. So under the dress code, there was no per se dress code for teachers. However, when she was hired as a coach, that fell under the AD's auspices. And the AD, in his testimony, had a requirement of professionalism. And under the case law, it's stated that it doesn't have to be written. And in doing so, Semple, when he testified, said that I expect my coaches to be professionals and show air professionalism. when he asked about Marchese being seen in a sports bra, she said, that's inappropriate. Your Honor, somebody has their hand raised.
Justice McDonald.
Counsel, what if this was a yoga class and she was in a yoga leotard?
Once again, the yoga leotard is not going to expose your private parts.
They're pretty tight. I mean, it's not exactly modest.
Your Honor, if you saw my body, you would say I'd never been to a yoga class. However, I think this is, when you're talking about a 14, 15-year-old, Your Honor, exposed, it's a different than being an adult session. An adult session, we can make our judgments, we have the maturity. 14, 15-year-olds do not. It only exacerbates the situation mentally and sometimes physically. But,
1 minute, counsel, for your
okay.
main argument.
AG Semple had this policy of professionalism, and that teachers should, or the coaches should not be wearing a sports bra. Now, we got the testimony of Coach Philippone, the head football coach, when asked about was there a dress code. He said, no, I'm not aware of Semple ever telling me about a dress code. So there's a conflict, a dispute as to the facts. And Semple had a dress code. Philippone said he was never told the dress code. And once again, this goes back to the Caddy case, where if there was a policy, it wasn't distributed to the coaches. If the coaches had known, they would have stopped this, nipped this in the bud, and told Marchese, stop wearing the clothes that you are. Do not perform like you did this. Do not expose yourself. However, the coaches decided that, unfortunately, that it was better to use her as eye candy. I hate to use that term, but that's what it came out to be, as we found in the testimony.
Thank you, counsel. You have your remaining time. Attorney Nitzel.
Thank you, Your Honor. May it please the court, my name is Catherine Nitzel, and I represent the Madison Board of Education, the town, and Principal Anthony Salutare. I'd like to jump right in on this discussion of attire and something that Attorney Bilczek said, which is that, or he was asked a question if any of the male coaches or boys were bare-chested, would any of those be problematic? And the testimony, of course, is that some of them were. And because it's a man, nobody seems to think it's a problem. So that's the first problem I have with these arbitrary standards of the propriety of attire. And as I argued in my brief, we already have guidance from an esteemed group of jurists, the federal court jurists who drafted the federal rules or the notes to the federal rules of evidence and the 1994 amendments, specifically determining that arguments as to a woman's dress as being indicative of her sexual proclivities is inadmissible. And it's inadmissible for the reason that probably Justice Keller, I'm going to suggest, might agree with me, is there's no evidence suggesting that someone's attire makes her more or less inclined not only to be interested in sexual activity, but to be a sexual predator. And that's the argument here. We're not just having an academic discussion about the propriety of her attire. Judge Abrams, in his opinion, acknowledged that it might have been inappropriate, although only a minority of the people who testified, of the 19 people, said that they thought it was improper. But let's assume it was improper, it was inappropriate. That is a far cry from making it a clue from which mandated reporters should have developed reasonable suspicion.
Counsel, there are questions from Justice Ecker and then Justice Keller.
I guess, part of part of my question goes back to a question I had for you in the last argument, which is sort of who's to decide. We've heard a bunch of questions giving hypotheticals about, beaches or yoga or men and women and all kinds of things, and they're legitimate questions. It strikes me that part of it just depends on context and circumstances, which is what juries decide all the time. Now, maybe the court should decide it, but normally, juries are asked to decide questions like this about, what's reasonable or not under circumstances. And the one thing we're missing here is we're talking about a bunch of 14 to 18-year-old boys. And I might be saying, treading on dangerous territory here to say so, but my own experience with 14 to 18-year-old boys is that they are full of raging hormones and tend to be highly sexualized. Not all of them, not to a pathological degree, but everyone knows that, and jurors know it. And so to say to normalize what the school did here, which was to put this woman in this situation with a football team surrounding her, just strikes me as unusual. Now, maybe shame on us, shame on society, and shame on 14 to 18-year-old boys. But are we supposed to sit here as a court of judges and say, no, this is fine, and this has no sexual content to it at all, and it shouldn't be expected to arouse sexual thoughts on the part of the viewers? Or should we let a jury decide that under all of the facts and circumstances?
Well, Your Honor, I think there has to be some basis to put in front of the jury to suggest that this attire is a clue to deviant sexual behavior. I think you're identifying.
Well, I mean, the woman was apparently voluntarily, dressed in a bra and shorts that at least one of the observers said exposed her genitalia. So, if that's true, and it's a capital if, I guess the question is that enough?
Well, let me address a couple of points. One is genitalia has a connotation to me, and there is no basis in this record to suggest that seeing the outline of a woman's buttocks underneath a yoga pant is not seeing her genitalia. I think that was a loose use of word on Mr. Bilczyk's part that finds no support whatsoever in the record. I mean, by that token, and I'm sorry to get explicit, but sometimes one can see a man through his pants, certain outlines of things. Can I see that man's genitalia? Of course I can't. And the other thing that I think struck me when I was listening to your commentary about the propriety.
And if that man was teaching an all-women's dance class and had extremely tight Speedo, wear on, maybe it would be, suggestively inappropriate. Or am I wrong? Or am I wrong?
I would respectfully submit you're wrong. What if he's a swim coach? What if that's what he's supposed to be wearing when he's coaching?
Well, in my hypothetical, is he's in a dance class.
Okay, but men in dance
and he's wearing clothing that's inappropriate for the occasion. It's not used. It's not what other people wear. I mean, look. If you could name me one other situation in America in which a high school football team has a coach conducting herself in this manner, it just, look, all I can do is base it on my experience as fellow citizen, and it strikes me as unusual. And apparently, it struck the coaches as highly unusual, to the point where they were talking about it. I guess I'm just objecting to normalizing it and making it a question of the sexism of the observer.
Well, I do. First of all, let's assume all the kids are heterosexual, right? Because it's only women that they would be attracted to under your hypothetical. So by having by at least suggesting it might be improper to have a woman coaching a bunch of men, the predicate assumption there is that they're all heterosexual, and only heterosexual males would have a problem with that. And of course, we know that's not true.
Well, that's your assumption, not mine.
Okay. What about the fact that, is it okay then, maybe we can only have unattractive women coaching, because it's only the attractive ones these boys might get their hormones raging on. See, this is where I'm going with all of this, that I think this is probably exactly why the judges drafting the 1994 amendment said this is all inappropriate. And so when you have a rule of evidence, I recognize not binding on this court, but when you have the federal rules of evidence saying that attire issues as attire is being introduced to suggest the sexual proclivities of an
Counsel, that rule is designed for when the woman is the victim here, right? I mean, here, she's a she may be a fine person. I cast no judgment on her, but she's a felon.
But regardless of for whom, first of all, the statute actually specifies it's for both the civil and the criminal context. And it doesn't say because as the victim, the notes to the rules does not say because she's the victim, the rape victim, and that's the original context of all of these laws. It's inappropriate. The basis for the rule of evidence is that it is an unreliable indicator of sexual proclivities. And that's what I'm suggesting. And just to kind of wrap this all up, the danger that you're identifying by having an attractive woman in her see-through Lululemons is that the boys get aroused. It's not that she might victimize them with predatory conduct. Under the Brooks v. Powers analysis as to what do we think is the foreseeable, the scope of the harm is not, as in Brooks v. Powers, a woman drowning in the Long Island Sound. It's by failing to, in the Brooks v. Powers case, as you no doubt remember, it's by failing to rescue the woman in the field, we think she might get hit by lightning, not drown. Here, by failing to address a woman's attire on the football field, the risk one would think would be that the boys would get distracted, not that we then make a conclusion about her not only having sexual proclivities, but deviant sexual proclivities.
Okay, I take your answer. It's a good answer. I appreciate it. It's difficult terrain, and most people probably would stay away from it, but I chose not to. I appreciate your willingness to engage me on the subject. Thank you.
Thank you. Are there other questions, or would you like me to continue, Your Honor?
Please continue, unless Justice Keller has a question.
Justice Keller?
Yeah, I had a question along the lines of, it sounds like she was a little bit of an exhibitionist. Would you agree with that? She liked to go jogging, not necessarily, there was evidence that she liked to go jogging and hear people honk at her. She kind of loved that aroused attention. You know what I'm saying?
I think there's no question, and her husband said.
All right, but we don't. Did anybody bring in any experts to say that this kind of exhibitionism and dressing a little bit inappropriately in light of your audience being teenage boys with raging hormones, etc., is a sign of deviant predation sexually?
No, not only was there not any expert, but one might have thought, Your Honor, that given the wealth of information we have, the curriculum from the DCF, who is required by law to conduct all of the DCF mandated reporter training in the state every 2 years, one might have thought that the appellants would have introduced some document from that curriculum that would suggest that the kind of conduct we're talking about here, and we talked about flirting before, it might have been interesting to see whether flirting observed was something the DCF teaches mandated reporters is a sign they should look out for. So we not only do not have an expert telling us what are the signs of a potential predator, we don't even have a single piece of paper from the DCF giving us any guidance to that effect. And if I may take this opportunity to address a little bit an argument raised before as to flirting, I just want to point out specifically what the testimony was about Rob Marchese bringing to his wife's attention his dissatisfaction with her. That can be found at Defendant's Exhibit 60, Appendix rather, A61. The verbiage is very important to note. The verbiage is he brought to my attention that he was dissatisfied with the flirtatious interactions. And flirtatious interactions is the verbiage used, not that he saw me flirting. We already have evidence that John Doe 1 was obviously flirting with her. We have no evidence that the sole basis for this fact that the court assumed is true, which is that Rob Marchese observed flirting, is testimony from Allison Marchese saying he was dissatisfied with my flirtatious interactions, which might have been unilateral, I would submit to this court. It might have been just John Doe 1 flirting with her, particularly since everybody admitted that that was obvious. I think the second thing that's important to know on this issue of flirting is that Allison Marchese, the one person who would have known whether she was flirting or not, her testimony, I didn't even know at the time my behavior was flirtatious. It was not until after years of therapy and being in prison that in retrospect, my failure to shut him down was in and of itself flirtation. So to the extent that the court wants to know what was the manner of flirtation, you know who tells us? Allison Marchese tells us. And even she didn't even realize it was flirtation. She needed a therapist to tell her. So when we talked a lot about flirtation, I would just please ask the court to keep in mind it's testimony from Allison that he didn't like flirtatious interactions, in quotes, which is very uncertain as to what that meant. And secondly, a woman who acknowledges even she didn't know her interactions vis-a-vis the child were flirtatious. Mr. Bilczek raises a point that we're going to see in the next argument is this notion that a ministerial duty can be established by the athletic director's directive that he thought people should dress professionally. That argument flies in the face of this court's findings, both in Northrop versus Witowski and in Ventura versus East Haven, in which this court specifically said in the Northrop case, simply by regularly having a schedule to regularly clean catch basins, or in the Ventura case, testimony by police officers as to what they would do if they found a unregistered vehicle. Those do not create ministerial duties. But it does sort of beg then the next question. Let's just assume for the sake of argument that there was some duty to, as expressed by the athletic director, to do something in the face of having seen Allison without a top on. The duty, according to the athletic director, is to tell her to put a shirt on. It's not to report her. The duty is to tell her to put a shirt on, which then begs the question, Justice Robinson.
Thank you, counsel. I believe Justice Doria has a question.
Oh, I'm sorry.
That's right. Let me take you in a different direction. Imminent, identifiable person, imminent risk. You take the position, or correct me if I'm wrong, that many of the incidents or knowledge would have, if it had come to somebody's attention, was after school hours. Therefore, it wouldn't fall within the doctrine. I guess, do you represent the Board of Education? Is that?
I do.
You do, yeah. That's one of the defendants. I guess I'm surprised that the Board of Education would take that position, that these weren't school hours, that you couldn't regulate conduct, that it wouldn't be something that would be under their control or on. Do you know what I mean?
Are you saying that because I took the position as advocating for an alternative grounds for relief, that there was no obligation? Is that what you're referring to? No obligation?
Yeah, I guess if your position is that it's not during school hours, so therefore, I guess the risk isn't imminent, that she would attack somebody during. Is that your position? That's what there was no imminent risk?
Oh, so are you identifying the fact that the discretionary act immunity exceptions defines identifiable victims only as those children attending school during school hours? That is the law with respect to, it was the law both pre Connecticut General Statutes 52-557 and it continues to be the law. So when we're talking specifically about discretionary act immunity exceptions, to the extent that the appellant is arguing they apply here, they apply, according to the law, only to John Doe 3 when he was attending school during school hours, and specifically then not to the voluntary summer conditioning practices and the after school training and anything that happened after school. So is the Board of Ed taking that position? Well, I, as their lawyer, am asking this court to apply the law, which is that discretionary act immunity applies only to identifiable victims, and he's not an identifiable victim outside of school hours.
Okay, and so maybe my quarrel would be, if I have one, is with our cases, is we have, I mean, school dances would be, a plaintiff couldn't fit themselves within that exception if some conduct was taking place at a school dance. I imagine she was either, I don't know if she was getting paid for doing the summer workouts, but this was somehow sanctioned by the school.
Well, first of all, there is quite a lot of case law that says exactly that, school dance or those sorts of activities. Anytime it's, and the way the standard reads is when the law doesn't require the child to be there, that child is not an identifiable victim.
Okay, thank you.
Counsel, as Chief Justice Robinson, I believe most of that comes out of Burns versus Board of Education, which is a case I don't want to say I lost, but I won it less than I could win it. And it dealt with the mandatory requirement of you having to go to school. And so you had this identifiable class of students. I believe where that comes from.
But there certainly is quite a lot of jurisprudence since Burns versus Board of Ed affirming the limited nature of the exception to discretionary act immunity.
I believe that, Justice Ecker's hand is down now. Justice Ecker, do you have a question?
No, I just forgot to lower my hand. I'm sorry.
Thank you. Justice Doria, do you have follow-up?
I would just like to address one argument that Attorney Bilczek makes on that point about an identifiable victim. He seems to think that because in 52.557N, the legislature didn't specify that an identifiable victim is to be considered only a student during school hours, that the legislature intended to abrogate the common law. And of course, that is not accurate. The legislature specifically said that it intended, in fact, to codify the common law, not to abrogate it. So I think the law as it currently stands provides relief in this instance to John Doe 3, should he be entitled to it, only to those activities which happened during school hours. The plaintiff, or the appellant rather, also addresses the other prong of the discretionary act immunity when he suggests that the dangerous condition, as the Haynes versus Middletown case calls it, that prompted a duty on the mandated reporters to address it. The dangerous condition was her attire, and we've already, I think, addressed that at some length. But then he also talks about the dangerous condition being the number of times his client, Doe 3, was in Allison Marchese's classroom. And without getting too deep into the weeds, it's just important to note that most of the time Doe 3 said he was in there after class, but after academic hours, but that's not the important inquiry. The important inquiry is what was apparent to the other people who were observing what's been called the comings and goings of John Doe 3 or any other student in and out of the classroom and her classroom. And Judge Abrams does a very good job at zeroing in on that and saying, that's the relevant inquiry. What is apparent to a municipal actor from which he or she would recognize he has an immediate duty to rectify the situation? And so I would submit that all we have then is a sophomore going in and out of a sophomore English teacher's class during extra help hours. And that's it. And the court didn't make an inappropriate finding of fact. The court merely highlighted what the evidence showed. The uncontradicted evidence of the teachers at Daniel Hand Middle School is that it was a campus environment where students were encouraged to go in and out of classrooms to receive extra help. So I would submit that on that basis, the identifiable victim imminent harm exceptions to discretionary act immunity do not apply. And so my client is entitled to immunity on that basis. Lastly,
Counsel, I believe there's a question from Justice Keller.
Thank you, Chief. I wanted to ask you about the claim that Mr. Bilczek made, that he seems to be saying that after this came to light, in other words, the police found out about the sexual assault on one of the other plaintiffs, his client went to a guidance counselor, told a guidance counselor he didn't want to be in Mr. Marchese's classroom, and he disclosed sexual inappropriateness by Mrs. Marchese with him, and that they failed to report it. I didn't see those facts laid out in any of the memorandums of decision. Was that really a claim that was made below?
You didn't see that because that's not what the facts said. The facts, the facts showed that Doe 3 denied involvement of a sexual nature. The principal knew merely that Doe 3 was a friend of Doe 1 and 2, and a software places placed the child in Rob Marchese's class several semesters later, and the Judge Abrams did address this. And by virtue of the fact that Doe 3 wasn't one of the children told to stay home on the day they had a big assembly, we can rightly infer that the school district didn't know of Doe 3's involvement, other than that he was a friend. And one of the reasons they didn't know is because Doe 3 denied it, both to the school and to the principal. I'm sorry, the police. He did not tell the guidance counselor when he asked to be switched out of her class, I was a sexual assault victim. He continued maintaining up until this lawsuit was filed that he was not a victim of any impropriety on her part. And so he asks to get transferred out. He doesn't say why. A couple of other teachers he tells his story to, but those teachers assume that since this has all been reported, the school knows everything, the police know anything. He finishes the semester with Rob Marchese, and apparently no harm ensued.
So he didn't for the first time disclose sexual inappropriateness towards him by her to any teacher until this was all discovered and all out in the public.
That is correct. And
all
even
right. But why wouldn't if he was always claiming that nothing ever happened to him and he finally confides in a teacher that something did happen to him, why wouldn't that teacher still have an obligation to report it?
Well, first of all, they deny that. He has said, oh, they told me the whole story. But remember, this is at the same time he's telling the principal and the police nothing. So I think the evidence is that, two answers that question very quickly. The evidence is that he wasn't telling people everything. He never said specifically, I told them I was a victim of her sexual assault. But more importantly, any teacher who didn't bring to the principal's attention what the child told him would have had a good reason to rely on the fact that she had already been reported, that the school had asked all of anybody who knew anything about this to come forward, and John Doe 3 did not come forward. I think Mr. Mastriani and Mr. Sola, who now John Doe 3 is saying, I told them the whole story, whatever that means, I think they would have had a reason to assume that had all already been reported.
All right, thank you.
Thank you, Counsel. You may add a grace note if you would like in closing.
Well, I appreciate the invitation, but I just want to say that to the extent that on this point, the claim is they should have, the teachers who were told the story after the fact should have come forward, and that should have been reported, begs the question then, what would have happened next? Well, what would have happened next is the police would have questioned him. And we already know what he told the police. So this idea that, oh, they should have still reported it because maybe they had new information. He had already once denied any involvement to the police. I don't know upon what basis the appellant now is arguing, had that happened, something different might have happened.
Well, since she was already arrested, I'm assuming there wouldn't be imminent harm. I'm assuming she was removed quickly from the school environment.
Yes.
All right, so she wouldn't be someone facing imminent, there wouldn't be a reasonable suspicion anymore that he was facing imminent harm, which is what the mandated reporting requirement is based on, correct?
Correct, but
Okay.
if the argument by the appellant is that the harm we're talking about here and the reporting is not mandated reporting harm or not sexual abuse harm, but that he wouldn't have had to endure Mr. Marchese's the uncomfortableness of being in Mr. Marchese's class a few semesters later, all I would suggest to you is that even after he was out of Mr. Marchese's class, something happened that brought John Doe 3 back into the principal's office well after the fact. Allison Marchese actually contacted him on social media and just asked how John Doe 1 was. And Mr. Salutary, the evidence is Mr. Salutary. So this is after he's out of Mr. Marchese's class. Mr. Salutary says to John Doe 3, nothing happened with you and Ms. Marchese, right? And he says, nothing happened. So John Doe 3 is very consistent all along. So all of these arguments about him telling people and what harm he might have avoided had somebody reported something bring us all back to the fact that John Doe 3 consistently and continually denied involvement in all of this.
Okay.
Thank you, counsel. Thank you, Justice Keller. Mr. Bilczek?
Okay, in closing, Your Honor, just take a few issues that were raised. John Doe, my client was in Marchese's class, pulled out of his classes during school 6 times. That's testimony. And there was another 6 times that he met with her in her class. Now, he met with her in her class between 6th and 7th period. 6th is the end of the academic period at hand, but however, there's a 7th period where there's like show choir, and it's a credit class still, and he was in that, and he would go to meet Marchese after the academic period. So I just want to clarify that. So it wasn't that, he met her after school. He met her in school, in her classroom, at between 6th and 7th period. Now, why the teachers had a duty to report? The teachers were told by Salutary of what took place with Marchese. And at that point in time, they only know 2 students were involved. What if there were others? What if they were my client? If they had come forward and said, hey, look, I had a discussion with Doe 3, I think you should talk to him more about it. He may be going to change. Once again, he was at the point in his, he's a 15-year-old kid, interviewed by the police, shaking in his boots, and he's saying that, hey, I wasn't sexually assaulted. He doesn't know what sexual assault is as a 15-year-old. The police just asked him, point the facts, just the facts. And he said, I wasn't sexual because he thought it was vaginal or oral sex, as what happened to John Doe 3. So here we have to give a 15-year-old a break because, once again, oops.
Mr. Bilczek?
I lost you. I don't know what happened.
We still have you. Can you hear me, sir?
Yes, I can hear you. Okay. Can you hear me?
Yes, sir.
Okay, I just lost you on something happened. Anyhow, so he was fearful. A lot of things happened. Can you hear me, Honor?
Yes, sir, we can.
All right. Because I'm getting different messages on the screen. So that's the scenario where reason why he kept it to himself, because he had fear. He's a 15-year-old. He didn't, this is his first time experience with the police, with any authority. But he eventually did come forward and he did seek psychological counseling. Now, I want to touch bases on that coaches are required to report for the state in Madison DOE child abuse policies, statute of policies. But the coaches are required to do so too. However, all the coaches, their activity takes place mostly after school and sometimes off of school campus. So why are they required to be a mandatory reporter, but all the case law has that has to take place during school? So that is, I'm confused as the case law that continues to say it has to be on school campus. Now, the other thing about Marchese is she continued to perform her core training exercises with the football teams in their skimpy outfits. And however, she was aware that it was becoming a distraction. And in doing so, she continued to perform these lewd performances. So she was well aware. all the counseling in the world later on. Geez, I didn't know what I was doing, but she was aware because she told the boys at one time, you have to pay attention to what the exercises are and keep your eyes off of me. But she continued to perform and show up with these outfits. So I totally disagree with that. She only found out herself later on in life. So I just want to raise also that off campus, there is a federal case, John Doe versus Torrington Board of Ed. It's a 2007 case involving a football player being bullied in Hayes off campus. And they relied on quite a bit of the Connecticut case law. So based upon this multitude of facts, and once again, summary judgment is driven by factual, by facts. I believe that the trial court's decision should be overturned and let the jury decide. Once again, they're reasonable. They understand. This is not a question of law. This is based upon facts. There's just too much out there and too much questions to basically dismiss this case as based upon law. Thank you, Your Honors.
Thank you, counsel. With that, we will be in recess until the third case, which is 12:30.